Hello, everybody. Adam Parks here with another episode of Receivables Podcast. Today, I'm here with another industry legend, Mr. Mark Cavin, who has served in a number of different capacities around the industry, and we're going to get into that today. But, Mark, thank you so much for joining me and sharing your insights.
Adam, it's really good to be here. Good morning, everybody.
Well, really do appreciate you coming on. For anyone who has not been as lucky as I have to become your friend through the years, can you tell everyone a little about yourself and how you got to the seat that you're in today?
You betcha. Well, I've been in the industry for 47 years. Believe it or not, I started really young. Having worked at Union Bank of California, I ran recovery and collections there, as well as small business workouts. Then I began selling debt with Judy Hammond early back in the days when the Debt Buyers Association was around. And then went to work for companies like Aero Financial Services, Sally Mae, Asset Acceptance, and Jefferson Capital, which of course were all in the kind of the debt buying industry. And I've been consulting in addition to that for about 25 years. So I have done quite a number of things and have been blessed in my career to have worked in the US, built call centers in India, South America, and Canada, as well as I've focused a lot of my time in the compliance and operational strategy area. Most recently, I've been spending a fair amount of time in litigation and strategic guidance, as well as have become an expert witness that we'll talk a little bit more about going forward. But it's I've been blessed to do it all. Started when I was 16, so now you can do the math, and now you know.
And you've also spent some time at the CFPB as well.
That is correct. Thanks for bringing that up. Prior to the CFPB, I was doing some work for the state attorney generals in the area of compliance and policy review, kind of at the state level, if you will, specifically. And then I joined the markets team with John McNamara, primarily focused in the collections vertical with Gandhi Ismail. We got right to the CFPB when we were rolling out Reg F, which was quite interesting. The markets team at the CFPB, for those of you who aren't maybe as familiar with it, are really a bridge between the regulatory compliance side of the CFPB and the street, a conduit of information going back and forth. I also was involved in the medical debt burden in the United States, a deep dive report when I was at the CFP, which was quite interesting. That led me to really open up my eyes with regard to medical receivables a little bit more than the experience I had. So I left the Bureau in February, and now I have reformed my consulting firm, Collection Intelligence. Goes by CI to make it easy.
Well, let's talk about that a little. What is it that you're doing there, right? You've got all this consulting experience, you've had a lot of opportunities to see behind the curtain in a lot of different ways, and you're understanding both of the industry side as well as the regulator side has to provide some unique insights. Talk to me a little bit about what you're doing at Collection Intelligence or CI.
Really, six different verticals. We deliver expert ethical solutions in debt recovery and compliance, as well as regulatory expertise, strategic guidance, and expert witness solutions. So, regulatory compliance and consulting to both the industry in all asset classes. I've been fortunate to work in all consumer asset classes, small business banking, commercial, as well as student loans. And then CI also does some work in collections and recovery strategy, applying operational experience and current new technologies within the industry. Subject matter expertise in litigation and support. When I was at a debt buyer organization, we acquired the assets of a litigation law firm and ran that and shifted the work from external to internal and blended, if you will, an internal external strategy, which led me towards, given my background, to provide expert witness solutions, if you will, in debt consultings. I have done and continue to do some sales generation for a couple of companies that I've gotten to know over the years that I feel really strongly about. Two I'll mention: CPC, which is Central Portfolio Control, a really good agency that's been around forever. And then on the medical side, Link Recovery Services, which is a master servicer in kind of the medical area. So, and I've spent a fair amount of time in student loan sales generation, having been at Sally Mae for some time. And then, of course, I do some public speaking and engagements, primarily around education and providing information to the industry to the extent I can add value.
Well, there's a lot for us all to learn about student loans with all the uncertainty coming down the pipe right now. It feels like it's kind of a big question mark out there as to what comes next, or at least not what comes next, but more about how it happens.
Exactly. I will say, given the CFPB's constraint in staffing and to use the term demise of the CFPB. Some folks within the industry are probably rather happy about that. But I will say the states have become extremely aggressive. And
Mhm.
if you're not paying close attention to statewide compliance and regulatory oversight, not only at the regulatory and new acts or laws are being implemented, but the district attorneys are now kind of getting in the game and looking at various components of debt collection disputes and debt servicing, if you will. One other point I'll make is to those who are happy, if you will, about the CFPB's lessening in enforcement right now, if the administration changes in 4 years, trust me, there will be a look back period, 4 years from now on things that are currently being looked at, if you will. So, from a compliance oversight perspective, I can't emphasize enough the need to really look at the state level activities and maintain federal compliance because of the complexity of the industry we're in.
I think when it first started happening, there were more people that were, I'd say, happy that the CFPB was being constrained, and I think on some level there was some constraint was necessary, but I also believe that move to the state level is a much bigger challenge for businesses to be able to manage. And I don't know that eliminating or restricting the CFPB in this way is the best move forward, because the political pendulum, as you mentioned, is going to continue to swing back and forth and back and forth. And I think that creates even more confusion. Having rules of the road is what the debt collection industry was looking for. And ultimately, I think got to some extent when it came to Reg F. But that's what I think the industry is really looking for, is just those rules of the road. You tell us what a stoplight looks like and what a stop sign looks like and what the rules of the road actually are. And I think that's where the industry, most of the players in the industry really want to find themselves.
So you're absolutely right. When I talk with the key executives at RMAI, as an example,
Mhm.
they are concerned and have been advocates of the federal regulatory oversight body, as well as some other industry based entities, if you will. So it's important to, as an example, when you look at Rhode Island and the new reg that they just put out recently with regard to medical debt, that if you
Mhm.
get a judgment and it's related to medical debt, you can't credit report it and you can't execute on the judgment if it was in fact an underlying medical debt. So that just points to the complexity and difficulty with regard to managing the environment that we're all in today. So it's good to, and where I think CI provides value as we deliver expert ethical solutions in debt recovery and compliance, as well as debt collection expert witness services. Litigation isn't going down. I would suggest that plaintiff actions are increasing. Saw recently in November, before the CFPB's reduction in staffing, there were about 155 regulatory items in play within the collections industry that could impact, the industry as a whole. Right now, it's at about 355 to almost 400 at the state level. So that kind
Mhm.
of illustrates, I think, the complexity of what the industry has to deal with.
Well, and it's the complexity of having to deal with it in all of these different locations. And now, how do you manage what's independent against what is good for the whole, right? So I think that it brings other questions to the forefront, new challenges in terms of having to manage segments of the portfolio in different ways when we start talking about this state level.
And about it, particularly as it relates to, debt collection expert witness services. There's case analyzation and report preparation. Certainly, I've been providing some testimony in federal and state court,
Mhm.
the deposition and trial preparation, an expert opinion on regulatory compliance and standards. I think what I can bring to the table and what CI brings to the table is, given the 47 years of experience that's pretty diverse and the actual application of that, I think we can speak to and support the industry and my clients with regard to plaintiff litigation, if you will.
Well, let's talk about what that actually means and where this need comes into the space itself. The debt collection industry is never short of litigation. There's always some litigation, whether it be between organizations, regulatory litigation, or there's always some sort of court actions that are happening. And there's only so many experts in the world that can stand up in front of a court as a debt collection expert and start answering the rather detailed questions as it relates to compliance expectations, operational, the reality, right, between what the rules are and how things physically operate. What kind of projects are you working on in that space to help organizations better understand, or to help even the court or a jury better understand what debt collection is and how it fits into the greater credit ecosystem?
I will say, given the frequency of litigation going on in the collection industry, particularly defense work, a lot of judges aren't really familiar with the complexities of the operational
Mhm.
components of collections, if you will. So you have to not only educate the judges, but you have to educate the juries to the extent there's a jury. So I think it's important to complex information and simplify it as much as you can so the jury can understand the material facts.
Mhm.
And that goes to an awful lot of research and boiling it down so it's simplified as it relates to the key points of the case. I think it goes to, in testimony, really understanding and applying the federal and state and local laws, if you will, or rules. And then certainly in deposition and trial, staying focused on the facts. I probably one of the best defense lawyers out there that I've run across that's an expert witness is, of course, Manny Newberger as an example. I think most people know him within the industry, but providing clear, defensible testimony and simplifying the complex issues really is important, particularly right now. Credit reporting, standing. That last couple of years, what does standing mean as it relates to the case? Is there standing? Is there not standing? And then you have, look at TCPA and what's going on recently with regard to at the high levels of the court with regard to interpretations.
Mhm.
Again, I think right now it's a bit of a plaintiff's lawyer game. And to the extent you don't have tight compliance management system and your procedures and operating processes are not clear and defined, when you go into court, having to define those and making sure that you have the information to support is really important. I think, given my experience in 47 years and CI's experts that we can bring to the table can offset and not only simplify and provide clarity when in court, but hopefully defend the industry as well as defend the consumer to the extent, which side of the table you're on and ensure a clear outcome that's reasonable. Explaining reasonability is an interesting one these days as well, right?
Well, even trying to explain anything about debt collection in a short period of time, it's a rather complex subject that's impacted by a variety of rules and laws at the state, federal, and even the local level. So, trying to provide an understanding of it in short order has got to be challenging. It's a rather complex topic that needs to be distilled and distilled and distilled, but still communicate the breadth of what is actually happening. And there's only so many debt buyer experts out there that are available to bring in to start having some of these conversations, because that provides an debt buying is a whole other layer of complication on top of debt collection, in my opinion. And how do you start to address those differences, right? So you really have to look at what is this case about and what are we trying to communicate here and how are we trying to communicate it, and then organizing and drafting the reports to go with it. Now, when it comes to the data to support the statements and let's say a report that's being submitted to a court, is it third party research? Is it just information from the case itself that you have to compile? What does the breadth of that work ultimately look like from your perspective?
Well, it really depends on the particular matter, but I'll use probably the most one I think the audience will most understand is when it comes to dialing
Mhm.
and communicating with consumers. What's a reasonable attempt to reach a consumer? How many times do you dial a consumer? Are you dialing the home phone? Are you dialing the cell phone? Are you sending emails? And how does one really define harassment as an example? In today's environment, we have just so many different forms of communication with regard to communicating this consumer. When you're trying to answer the question of a definition that isn't clearly explained from a regulatory or law perspective, it becomes somewhat complex. So, what do? You look at case laws, other case laws that may have some standing or basis of the fact pattern. You do research that's in depth with regard to, a spectrum of years, let's say, to create a story. You talk to consumers as well as to lenders as well as servicers to understand what their policies and procedures are. And you look at things like in the Card Act, where information is provided on the basis of, let's say, a number of institutions that report every other year to the CFP with regard to what practices are, to establish what is, to the term I used before, reasonable, what's not reasonable.
Mhm.
So ultimately, it's left up to the determination of a jury, which you need to simplify and make sure that you stay close to the fact pattern and they understand it. And of course, that the judge really understands. And it's within the framework of the guidance or he or she that's providing with the case. That
Okay.
makes sense.
Yeah, that makes sense. So, I mean, when I start to hear that, though, I still hear about the distilling of the complex ideas down to a more simplified methodology that is capable of being communicated to, whether it be the judge or the jury. In that, if assuming there's a jury, and what does that ultimately start to look like? It does sound like that's a rather complex undertaking. How do you even begin walking down that path, Mark? Because somebody comes to you with a case, like, where do you even start? Like, what's step one in the journey of 1,000 miles?
Absorbing a lot of information.
Okay.
A, B, understanding the facts and
Mhm.
the relevancy to the case. Three, being able to tell the story as it relates to one and two that I just mentioned. And then articulating those facts to create a foundational argument that's supported by that information to get the ultimate outcome. Sounds simplistic. Just like collection is easy, right?
Sure. Sounds like you've got a process to build a process
That's
is what
correct.
I'm hearing. Like there's a procedure to build the procedure in order to get to the end result that you're looking for,
Exactly. Yeah.
which sounds rather complex, but for someone who's been consulting for, 25 plus years, that seems like it's probably not as complex for you.
No, it's not. I guess because I'm able to I've if you will walked the talk,
Mhm.
and having run large call centers of 1,600 people or so, and having worked with collectors and being able to communicate is probably foundationally important, and making sure that structure you obtain the right information to create the basis to support the case, right? And that's a lot of different pieces there. We could probably spend the next hour just on discovery or interrogatories or the capturing of data and understanding that data as it relates to being, let's say, an expert witness. How the other side's going to approach you and try to rattle you and get you off the mark, if you will, depending upon what the circumstance may be. So I've been fortunate where I've worked on cases where I'm in essence supporting the attorney general
Mhm.
or the industry. That could be a law firm, that could be a collection agency, that could be a debt buyer. I see myself really as eccentric in support of the consumer as it relates to fair practices. So I think having seen a lot of different things from running a recovery department to running debt buyers and selling inventory and building call centers offshore, in today's environment, the consumer is really centric. And depending upon the approach and strategy you're applying is important, as well as being mindful of compliance and reasonableness. And that whole concept of reasonableness, I think, is really at the center of a fair number of these cases. Certain cases are black and white. I really like the cases that are a lot more gray, if you will. So we can define, if you will, the outcome that could benefit the industry, if you will.
Okay. I like that approach. So you're collecting the information at the beginning of the case, then you're organizing all of that so that you can start to really understand as you go through the process of the case, going through the discovery process, going into interrogatories, and having a organized way in which you can recall that information. Like when I
Absolutely.
think about these large projects, like writing the TransUnion report, and how often I have to refer to the data set that's in front of me in order to write a coherent report that draws an analysis, comes to strategic conclusions, and ultimately gets published. I imagine it similarly, not because that you're creating the same thing, but because it's taking a massive amount of information, distilling it down, and having to constantly be able to refer back to larger data sets in order to communicate cleanly, clearly, and effectively the end result.
It's a really good point. Coming back to the report, in any case that I engage, let's say on behalf of a regulatory body, what I will do oftentimes is once I understand what the foundational elements are, I look at it like a problem statement.
Mhm.
What are we trying to solve for? What are the issues? What are the underlying issues and what are the underlying laws, right? And then once you understand what the problem statement is or what you're trying to solve for, then it becomes an outline. So within that outline, what are the components within that outline? And
Mhm.
then what are the stories within the outline and how do they connect within each other? And do they create the argument around the statement of the issues or problem statement? So ultimately, a summary level report can oftentimes in a case be 20 or 25 pages, and the report can take several months, which covers an awful lot of data, which then becomes the foundation before you get into testimonial activities such as, post interrogatories, when you get into deposition and you get a trial. And oftentimes the judges will review that report in depth. And if you write it the right way, then it helps the judge get a foundation of understanding, because oftentimes many of the judges, particularly at the state and federal level, don't oftentimes understand the intricacies, if you will,
Mhm.
collection processes and how you can relate to those collection processes. So the report becomes foundationally critical and important, not only to build credibility, but to understand the elements of what you're trying to solve for and what the case may ultimately be designed for before you get into arguments. So research is extremely important as it relates to that process.
That makes a lot of sense, which means to me, when I start thinking my way through this, it sounds like it's the perfect job for someone who does consulting, right? A professional consultant who can take these complex ideas, simplify them, distill them, and then create a deliverable report on the tail end that actually communicates the final product. And that, I think, is also another challenge, right? Just being a debt collection expert is never enough in that aspect. You have to be able to, you have to be a powerful communicator, which has been your reputation for the last many years, right, is being able to cleanly, clearly, effectively communicate. And I think that seems like a really nice tie-in. So when you think about this new business, right, collection intelligence, and you've got this focus on the expert witness testimony, and being able to provide those types of solutions, talk to me a little about how that crosses over to the other types of projects. And I mean, the skill set that you've developed, right, as a consultant, you're using it in that aspect for the expert witness testimony. How are you carrying that across into the other areas of consulting that you're doing?
Yeah, consultants are really investigators. We're
Mhm.
researchers, right? So it's like mining a treasure to kind of find the gold to a certain extent, if you will. When I'm consulting, I'm an active listener. Let me understand what you're doing, how you're going about it, and where the opportunities may be. I do know one thing that I can try and communicate. If I can communicate a little bit better each and every day, and I listen, actively listen, I can oftentimes pick up materially what's really kind of at the root of the issue of what's going on. So my consulting business, it's a lot of listening, it's a lot of understanding, and it's a lot of really understanding the opportunities and developing a plan, if you will, to the extent that the client can identify one, two, or three things. I know one thing you can't, when you go into a consulting gig, you can't solve 10 things. What are the one or two things you can really solve for and build on and measure the outcomes, right? I'm a strong believer in measuring the outcomes of whatever deliverable you implement with your client. As a matter of fact, in some of my consulting gigs, what I've done is I've gone in at a reduced rate with the opportunity to get some upside on the back end side once the opportunity or implementation has been realized.
Mhm.
So in the expert witness side of things, it's similar. Again, you're trying to communicate the outcome of what your understanding of the problem statement is or what you're trying to solve for. But I see the ultimate measure outcome being the jury or the result or
Mhm.
the decision that's made by the court, if you will. That's where the true measure comes in and the
Well, that's
benefit.
interesting. It's the interpretation from, right, like your targeted audience, and your targeted audience when you're going in to do strategic consulting is going to be the end users and ultimately the consumers behind that. And when you're doing the strategic consulting, your ultimate customer is the consumer account holder that sits behind everything, because your ability to impact and change their behavior towards payment is ultimately your goal. When it comes to the expert witness side of things, your ultimate goal is to make sure that you're educating the judge, you're educating that jury, if there's a jury, in order to position or I mean, it's really an education either way. You're trying to influence behavior in some way, shape, or form.
Yeah, and provide, transparency, not only in transparency, but the impacts of that transparency to the consumer and or whatever the issue may be before the court. Collectors in collectors have, to use the term, a bad name, right?
Mhm.
When What I really like is when a collector has a good outcome of the consumer is happy that there was transparency, that they were dealt with a certain way. I think, 99% of people who have debt would love to resolve debt. And the trick for us, of course, is to find a way to do it in an empathetic, compliant, regulatory manner. But, right out of the gate, when you're in court and you're representing or you're part of the side that's the collection industry, you've got to overcome that
Mhm.
stigma that, that all collectors use a certain approach. Well, that's not the case. The collection industry provides well over $90 billion back to the ecosystem as a whole within the industry. And on the debt buying side, it was actually the Treasury that began the process of debt buying back in the days of the demise of some of the banking laws and
Yeah.
institutions when they failed. So they started selling debt, and that really provided value given the economy as a whole. So I think
Mark, you got to go way back to start talking about the RTC
the
auctioning off
RTC,
bank
but you
assets during the savings and
no,
loans
yeah,
crisis of the 90s. I did an episode with Mike Colby on that. Not, it was probably a few years ago now
right,
because he was working for the RTC at the time
sure.
as it was birthed. But I don't know that everybody goes, I don't know everybody truly understands the history of the debt buying industry that.
But, to use that as an example, I think when you're in front of a court or you're in front of a jury, not everybody knows that. Not everybody understands the value and the importance of a debt collector. Or on the regulatory side, the importance of oversight and consistency to the consumer as it relates to treating them fairly. So again, it goes back to the nature of the issue before the court. But I think foundationally, educating the court, educating the jury is just as important as writing the report around the foundational facts of the case, too. So, although simplistic, complex, right? So, then we begin to overlay politics, to use the term politics,
Mhm.
into the kind of square of the problem becomes even more interesting because politics oftentimes drive different desired outcomes. It can create cloud or the jury or cloud the issues and facts that you have before you. So, it's another complexity that you need to overcome. So that's why I think it's important to be able to write a clear, good report, understand the problems you're solving for, articulate those. And then when you're either being deposed or you're in front of a jury and a judge, being able to explain that complexity in a simplistic way so they understand it and educate them.
Well, Mark, this has been a fantastic discussion. I really want to
Right.
thank you for coming on and sharing your insights with me today. I always appreciate an opportunity to have a chat with you. Is there anything that I didn't cover today that you wanted to say to our audience?
No, other than CI is here to help you. You can find me at www.collectionintelligence.org. Here
I
to
will
help.
put that in. I'll put the link below as well.
I appreciate that. Thanks, Adam. Appreciate the time today.
Well, I really do appreciate you coming on, Mark. For those of you that are watching, if you have additional questions you'd like to ask Mark or myself, you can leave those in the comments below and we'll be answering those. Or if you have additional topics you'd like to see us discuss, you can leave those in the comments below as well. And hopefully I can get Mark at least one more time to help me continue to create great content for a great industry. But
Here's
until
a
next time, Mark, I really do appreciate you. Go ahead.
here's an idea. I got an idea for you. For anybody out there that would like to meet with you, I'm going to be at a DCS, Debt Collection Symposium,
Mhm.
coming up here in September. And then I'm going to be at Compliance Com in October. So more than happy to meet with you. Maybe we can do a session at one of the conferences, Adam. Just let me
Maybe
know.
we can, but I'm going to be gone in October. I'm going to Brazil, but we'll make something work, Mark.
All
I
right.
look forward to spending some time on stage with you. But
Thanks.
again, thank you so much for joining me. I really do appreciate your time and attention, and thank you everybody for watching. We appreciate your time and attention as well. We'll see you all again soon. Bye, everyone.